This was filed again yesterday. Motion to suppress identification evidence. Comes now the defendant through undersigned counsel and pursuant to the 8th and 14th Amendments to the Constitution of the United States and Article 1, Section 1, Paragraphs 1 and 17 of the Georgia Constitution of 1983, moves this court to suppress as evidence in this case the testimony of any witness as to pretrial identifications of the defendant and to prohibit any in-court identification by the witnesses, and in support thereof shows as follows. Defendant anticipates the introduction of eyewitness testimony in this case, including a live and or photographic identification of the defendant. Defendant believes that the identification procedures were so unreliable as to give rise to a substantial likelihood of irreparable misidentification. Here, the alleged victim stated he was approached from behind and robbed at gunpoint by 2 black men in masks. He believed he recognized one perpetrator from a physical disability not possessed by defendant. He did not identify the second perpetrator by name, nor did he provide any physical description of the defendant's face, size, gait, clothing, scars, tattoos, or any other identifying mark, as his estimate of the second perpetrator's size does not fit the physical stature of defendant. Nor did alleged victim provide any identifying statement attributable to the second perpetrator, believed by authorities to be defendant. Okay, so 2 people are accused of robbery here. There's a description given to someone that's purportedly supposed to be with Christian Eppinger. They believe the second perpetrator is Eppinger. They don't describe Eppinger, but they describe the first perpetrator, and the description doesn't match who the state is saying is the first perpetrator. So that sounds a little messy if we take this at face value. A pretrial identification by police via photo lineup was conducted, whereby defendant was identified as the perpetrator of said offenses. Now, this could be a whole separate conversation, but in general, short summary in the chat, YouTube limits your character count. What is your opinion of photo lineup integrity for identification, just generally speaking? 3, defendant was not represented by counsel at the time of the photo lineup, and the procedures used by police and state official in conducting the same were designed to focus upon defendant. So it seems like they're alleging that the police were steering as part of this identification. Here, the alleged victim did not identify the named perpetrator during the first photo lineup conducted. The defendant was identified during a second lineup, where the officer conducting the lineup, pulled defendant's photo from the 3rd position in the stack of photos consisting the lineup and placed it on top of the stack in the presence of the alleged victim, upon which the alleged victim selected defendant's photo. So, how are you visualizing this? We've got this lineup. We go through round 1. Nobody recognizes the defendant. Nobody recognizes Eppinger's picture. The alleged victim doesn't say, yeah, that one. So then they do it again. They shuffle after you've already looked through something that contained Eppinger's photo. They swap out all the other photos with new photos. Add in a photo, or keep the same photo maybe of Eppinger, maybe a different one. I don't know how many photos they have. But this alleged victim went through round 1 and got to see Eppinger's face at least once. So they switch all the other pictures, but Eppinger, same photo, different photo, Eppinger's still in this second round. And then the officer, according to this motion, is moving that particular picture to the top. And then the alleged victim goes, okay, that one. But what's the problem with that? Human mind works in funny ways. If I saw that photo previously, and then I see that same face, the second round I've got to go through this, my brain, and I might genuinely think that's the person because I'm recognizing it as being familiar. I might not try to be malicious and say, yeah, whatever, I'm just going to pick this one. But something in my mind could say that face looks familiar. Why? Because I've seen it previously in the first round of this. This seems a bit problematic. If we take this at face value, this seems problematic. It is, of course, well established that there is already a, quote, great potential for misidentification when a witness identifies a stranger based upon a single, brief observation in a stressful situation. United States v. Russell, the innumerable dangers inherent in such identifications, which have led to a high incidence of miscarriage of justice, were described by the United States Supreme Court in United States v. Wade. As the court observed there, the lack of reliability of such evidence is well documented. The Due Process Clause of the 14th Amendment protects an accused against the admission of unreliable identification evidence. That's Manson v. Braithwaite, Lyons v. Johnson, because the intrinsic unreliability of eyewitness identifications is so often compounded with the distorting effects of the natural suggestion to the witness that the person on trial is the guilty one, right? We've talked about that with the YSL trial. Why are we here? Surely we wouldn't be here if the police didn't do an investigation and figure out who was doing this stuff. You know, there's already a hurdle to overcome just by the fact that this is in a trial, in a courtroom, making sure that human nature doesn't steer us to think, well, surely somebody must have done it. Why else would the defendant be sitting here? Then on top of it, you add in eyewitness identification problems. So they're saying here, they're quoting here this Lyons v. Johnson. This is a great point, that the intrinsic unreliability of eyewitness ID is so often compounded with the distorting effects of natural suggestion to the witness that the person on trial is the guilty one. It is no exaggeration to venture that the influence of improper suggestion upon identifying witnesses probably accounts for more miscarriages of justice than any other single factor. Perhaps it is responsible for more such errors than all other factors combined. And we're going to pull up a database. We're going to look at some exoneration data. Such evidence must be excluded where, as here, the totality of the circumstances indicate that the entire identification process was unreliable and thus resulted in a substantial likelihood of misidentification. And then they cite here Neal v. Biggers, Simmons v. United States, and Thornton v. State. Here, under the totality of the circumstances, there exists a very substantial likelihood of irreparable misidentification because the photographic identification procedure here was so impermissibly suggestive, as the alleged victims did not have a good opportunity or long time to view the perpetrators, as the robbery only lasted lasted seconds. In addition, the perpetrators were wearing face coverings at the time of the robbery. So, 2, could only have possessed a low degree of attention to the perpetrator's identity, as the presence of the weapons and the assailant's various instructions and demands surely affected the alleged victim's degree of attention. 3, did not provide an accurate description of the criminal prior to the suggestive lineup, as the physical description given does not match defendant. And I would say, I think as much as I want to say objectively that this has reliability issues, right? How much can you really think or recall in the moment? The problem is when somebody sits on the witness stand and identifies someone as being the person they saw in that moment, that is compelling to juries whether it should be or should not be. But when you get into further stuff like this, well, they gave a description that clearly did not match the defendant. That's a bit more significant, right? Well, you said they look like this, but this does not look like that, does it? Right? Then 4th, they say demonstrated a degree of certainty in the identification of defendant as a perpetrator only after the suggestive act of placing defendant's photo on the top of the pile of photos by the officer in the presence of the alleged victim. 5, only identified the defendant during the suggestive lineup performed 8 days after the crime, after providing no other piece of identifying information of defendant in the 8 days. 6, based his identification upon inducement by the conduct of the lineup and not upon observations at the time of the assault at all. So, I don't know. Because pretrial identification was obtained by law enforcement authorities in violation of the defendant's constitutional rights, the prosecution can elicit an in-court identification only by showing, by clear and convincing evidence, that any in-court identification would rest upon a source independent of the illegal pretrial identification procedures. So you've got to find another way to ID, because this photo lineup where you stack the photo, that shouldn't cut it. That's a violation. The defendant submits that the prosecution cannot make the requisite showing in this case. So the defendant saying they don't have somebody else. Our appellate courts have disapproved of such practices as one-person show-ups. So that's Baines v. State, confirmation of selection from photo spreads, Dodd v. State, Lowe v. State. And sometimes, guys, when we see older cases, I know we might be like, oh, they're reaching. But when you're showing multiple older cases, the argument there is that this is well established. This has always been a problem. And one person in court identification, State v. Fry, where the trial court properly excluded evidence of out-of-court identification and in-court identification on grounds of impermissibly suggestive identification procedures. Barring suppression, the defendant moves in limine to prevent any testimony by law enforcement agents regarding the alleged identification. So even if they can bring in that this alleged victim identified somebody, maybe through the witness themselves taking the stand, they want to bar law enforcement from being able to get up there and testify to the procedure and the same thing. And a win there would be sometimes when you hear things repeated, and we saw this strategy with the YSL trial, just put 5 or 6 gang experts up there and have them say the same thing. And maybe because we say it so many times, it'll stick. It'll stick. But at least if you don't want to suppress this entire identification, don't let an officer get up there and bolster it and repeat that, yeah, this identification was made. In totality, the pretrial identification procedures used by police officials were unduly suggestive, and therefore, any evidence as to pretrial identifications or in-court identifications will be tainted. So, wherefore, the defendant requests this court to order a pretrial evidentiary hearing on the matters set forth above, and further requests that any such illegal identification be suppressed from the trial in this matter. So, I'm not sure if they'll handle this type of hearing, if they'll, if they filed this on the 6th, and it is Whitaker's courtroom, hold on. They want to have this other hearing on the 13th. How many business days is that? Is that 5 business days? So if they got receipt of this yesterday, 7, 8, 9, 10. So the 13th would be 5 days. So if Whitaker counts this as being submitted to the state, they'd have their 5 business days to respond by the 13th. So maybe they'll hear this on the 13th when they go over the immunity motion. So I don't really see anything indicative on the docket that shows a specific hearing set for this. We just know that on the 13th, we already had that immunity motions hearing scheduled. It just says motions hearing. So I think they could discuss this then. There's 5 days in between. And then again, on the 17th, we have the final pretrial conference for all the remaining defendants, unless there's an issue that pushes the trial back. So there you go. I'm going to link this again. This is pretty interesting.